Hello. Hi, everybody. Welcome to Children of Darkness and Light. Please let me know if you can hear me. We were having a little bit of trouble with getting set up just before we went live. So please let me know. Can you hear me? Great. Thank you, Aquamoon, for letting me know. Technology always it gets one step ahead of us. So thanks for letting me know. Welcome, everybody. I missed you on Wednesday, but I was on my way to Rexburg. I also had dinner with a couple of our favorite followers from Idaho Falls, and that was great fun, and I appreciated being able to spend some time with them. I got over to Rexburg later in the evening. I actually stayed in St. Anthony at the one little motel that's in St. Anthony, which was an adventure, and went to court first thing in the morning. Drove back after court yesterday, and here we are today with so much to talk about what was going on in the courtroom, as well as the decisions that Judge Boyce made having to do with the Vallow trial and Daybell trials. There were a number of motions that the judge heard. Chad and Lori were both in the courtroom initially. Let me just sort of set the scene. Chad and Lori were both in the courtroom when I got in the courtroom. Chad was already seated at counsel table. His attorney, John Pryor, was there. Lori was not there, but it was clear that the courtroom was set up for both of them to be there. So shortly before 9:30, when the the hearing was about ready to start, they brought her in. She was dressed in her usual light pink polyester blouse and some dark slacks. She still looks very thin. She had on what looked like kind of Ugg style boots. It had been snowing, and there has been snow on the ground in Rexburg. Not a whole lot of snow, maybe a couple of inches. The roads are clear and the sidewalks are clear, but there has been snow. So she was in snow boots and not her usual heeled shoes or boots. And so she came in and sat down. Her hair was curled. She seems to have perfected the art of curling your hair on a scarf or on rags, because her hair was curled. And she sat down, and the court judge came on the bench, and they started off right away. The judge took up the motion to continue. And I know that's what everybody has been most concerned about, me included, because there's a lot of moving parts going on. So we wanted to everybody wanted to know whether or not the court was going to was going to continue that hearing. So John Pryor started out making his argument. For those of you who may have read the motions, you might recall that John Pryor's original argument was that he did not have time enough to do the mitigation that was going to be required for a death penalty case. Now, mitigation has to do with the penalty phase, with whether or not the death penalty is going to be imposed. And so there's always an issue of having to toilet paper roll curls. No, I think what she does is what you see on TikTok, where they take a scarf or a rag, kind of long, and then they wrap the curls or the hair around them. Remember, she has naturally curly hair anyway, so she's kind of trying to tame natural curl by doing that. Anyway, back to the important stuff, the hearing. So John Pryor's original argument was that he didn't have time to do the proper mitigation for the hearing because he had just hired a mitigation specialist. But when he got to court, he promptly launched into an argument about whether or not he had all the discovery. You might recall we've heard many discussions about this consumptive DNA and whether or not this consumptive testing on a DNA sample, and whether or not there was going to be sufficient sample to be able to pull a DNA profile, and whether or not there was going to be a sufficient sample to allow more than one test. So back in August, we were talking about this, and the parties stipulated, that means they all agreed on a process for how they were going to use that DNA, whatever DNA was available. So it turns out that even though they agreed months ago, that DNA still has not, the reports have still not been produced. And it appears that they still have not been tested. Here we are, less than 90 days away from trial date. So state forensic labs, state testing labs are kind of notorious for being underfunded, understaffed, and backlogged. Although it is interesting because this is the same lab that expedited all of the testing for the University of Idaho Brian Koberger case 2 weeks ago. So it is sort of interesting that they can speed things up when they want. So it's alarming, of course, that DNA testing still hasn't been done. So in addition to that, apparently, as the lab has examined some of the material that was submitted to them, they have discovered at least a couple more suspicious hair that they want to test. So in addition to this, the testing that hasn't been done yet, we also have 2 new pieces of evidence that need to be tested as well. Now, as I say, when the Brian Koberger case kicked off and they needed to have DNA testing to match his DNA to his father's, they had the materials picked up in Pennsylvania, brought them back to Idaho, and did all that forensic testing in the Idaho lab, same lab where they've been doing the Lori Vallow, Chad Daybell testing. But we know that crime labs tend to be pretty notoriously backlogged. Over the past few years, the Idaho forensic lab, this one, has been working hard to catch up on thousands of backlogged rape kits, somewhere around 1,100 actually backlogged rape kits. And they have finally gotten to the point where they have no outstanding or backlogged rape kits now, but it's taken them since 2016 to do that, when the original backlog was identified. So it's not necessarily surprising that they've got a backlog in DNA. I want to mention, while I'm thinking about it, I'm going to take questions. We'll probably take questions in about 10 or 15 minutes. In the meantime, I want to just give you all the information I know about what happened at the hearings, and then we'll take questions. Please hold your questions until we get to that point and we ask for them. It just makes it easier for our moderators to find your questions and make sure that they get posted. So hold on to them. If you have a question, start the post with the word question, because that helps them identify them quickly, because our chat moves pretty quick. Okay, so back to what happened in court. So although the judge was not overly sympathetic to the issue of whether or not John Pryor had had time to hire a mitigation specialist, He was particularly concerned about the fact that there was DNA testing that had not been done. The primary reason being that that information is required to be turned over to the defense in case it may be exculpatory. So the judge expressed some real concern over the fact that there was potential exculpatory information that had not been tested and not been provided to the defense. So ultimately, what the judge said was he was denying John Pryor's motion to continue the trial, and the trial would go forward in April. As we discussed last week, and I've discussed in my newsletter, when you take the two competing interests, so on one hand, you have Lori Vallow, who has not waived her right to a speedy trial, and on the other hand, you have Chad Daybell, who has waived his right to a speedy trial, and is complaining that it would be ineffective assistance of counsel not to allow him more time. The judge is going to err on the side of the speedy trial issue. That is the weightier issue, and it certainly has the most serious consequence should her speedy trial rights be violated. As we talked about last time, depending on how long the delay has been and how egregious it is, how outrageous really the violation is, the Supreme Court could say this violation is so bad that we are going to dismiss the charges with prejudice, meaning the state can't bring them back again. So it acts like double jeopardy. You can't rebring the charges. That's a big consequence. The worst thing that could happen if Chad Daybell, on the other hand, files an appeal for ineffective assistance of counsel, the worst thing that could happen to him is he could get a new trial with a new lawyer. So the judge has to weigh those two things and say, well, what is the worst outcome? The worst outcome is we don't want anyone who is guilty of murder to walk away scot-free. So the judge denied the motion for a continuance that ordered that the case will go forward in April. But he did say to the prosecution, if you don't get that evidence ASAP, the prosecution's responsibility is to ride herd on that and to put pressure on the lab to get it done. If you don't get that done, I will consider severing the trials. Now, I guarantee you that the prosecution does not want the trials severed. They don't want to try these cases twice. They don't want witnesses to be able to practice on Lori's trial and then come back and get a redo on Chad's trial. They don't want that. So I guarantee that Rob Wood or Lindsay Blake are going to be standing in the lobby tapping their feet and pointing at their watch until they finally get that information tested and released. It really is no fault of the prosecution's, other than the fact that the prosecution should have been sitting in the lobby tapping their foot a month ago to make sure that this wasn't going to be an issue. It is my impression that they have played a little bit lax with their discovery obligation. I think that they should have been from the outset looking at, have we met all our discovery obligations? Is there outstanding discovery that we need to follow up on? We absolutely need to be certain that we have fulfilled our obligation, not only because it's the right thing to do, but because it's going to avoid appellate issues in the future. So where we stand right now is the case is going forward on April 3rd. The judge has already said that he hopes that they will be able to move forward in perhaps begin jury instruction or jury selection in late March, depending on whether or not Ada County can accommodate them. And the judge is saying the trial's going to go forward on April 3rd. But if that DNA has not been produced and there is a possibility it could be exculpatory, Chad's trial may not be going forward. It may be only Lori. That is going to be a nightmare for the prosecution. So I think that they are going to work really hard to get those pieces of evidence, that those DNA reports. I would be very surprised if those DNA reports aren't produced in the next 7 to 10 days. While I'm thinking about it, and I'm seeing these wonderful super chats go by on the chat, I just want to say thank you so much for anyone who has generously donated. And I want to remind everybody that all of our super chats, all of your donations, all of your PayPal donations go directly to our moderators. So if you're thinking about our moderators, Michelle and Brenda, tonight, please think about dropping them a few bucks and buying them a coffee or a glass of wine. Oh my goodness. I have a Siamese cat behind my computer who's decided to have a chat with me. So the next, hang on just a minute. Oh, he's going to move on his way. The next motion that was heard was the motion to sequester the jury. And the defense were all opposed to it. The prosecution wanted the jury sequestered. Clearly, we're looking at a 10-week penalty phase, or a 10-week guilt and innocence phase, followed by a penalty phase. Now, Idaho statute requires that the jury be sequestered during the penalty phase. So once the guilt or innocence phase has been has finished, if they are found guilty, then the penalty phase will start, and that will be the decision on whether they are going to receive the death penalty or whether they have mitigated the death penalty. So right now, the 10 weeks that they have said this trial is going to take does not include the penalty phase. So a sequestered jury is looking at probably 10 weeks of guilt or innocence phase and another maybe as much as 4 weeks of penalty phase. So it would be a real hardship on anyone to have them to be sequestered for as much as, say, 14 weeks. Because during that time, they wouldn't be able to be at home, they wouldn't be able to work, they wouldn't be able to see their children, they wouldn't be able to run their businesses, many, many things they would not be able to do. So the judge said he believed that there were options, other options to make sure that the jury was following jury instructions and appropriately had received appropriate instruction on not talking about the case, not reading about the case while it was going on. Yes, that is a pair of ears sticking up. He's decided to come around the front of the computer now. So far, the judge has denied 2 motions. The judge refused to sequester the jury and also denied the motion to continue. Although the judge in the motion to continue did caution that if, in fact, the final DNA did not get processed, that there was a chance he could sever those cases. So then the next motion was one everybody was pretty interested in, and that was a motion from Lori's attorneys to allow them to have some face-to-face meetings. This is a really unusual motion. I'd never seen anything like it before. And I've never had a co-defendant case where co-defendants were allowed to strategize or to get their stories straight. Although I did understand the reason why Jim Archibald was asking for it. And it became very clear at trial or during the hearing. Because Jim Archibald very clearly said they had received a letter from the prosecution that includes a proposed plea offer. And when they presented it to Lori, she said, before I can make a decision, I want to talk to my husband. And so, I mean, I don't think that it is all that unusual in cases where weighty decisions have to be made for a defendant to say, I want to talk to my spouse or my mom or so. But the unusual part of it here is that her spouse is also her co-defendant. So the judge kind of ran through all of the issues that he saw with allowing the two of them to talk. Said that he did, while he understood the reason why, he did not feel that there were adequate safeguards that would allow them to visit securely and without waiving their attorney-client privilege. So the stickiest part of it is when an attorney and their client talk, those discussions are absolutely private and are absolutely privileged. So they can't be discovered in court. Witnesses can't be subpoenaed. The attorney can't be forced to testify. But if there is another person in the room, even if it's another lawyer, the defendant, the other co-defendant's lawyer, does not have a duty to keep private the other defendant's private information, meaning that opposing counsel, co-defendant's counsel, could be called as a witness. And that's a big problem if you are talking about the ins and outs of the case. It was interesting that John Pryor very clearly said, I don't intend to strategize with anyone. I don't believe these are strategy sessions. I think these are sessions to prepare for trial and to have discussions about witnesses. But I don't believe that that there should be any sort of a strategy session. I have a defense I'm going to present, and strategizing doesn't play into that. So it was a little interesting that it appeared that John Pryor, and we have to attribute some of this to his client, that John Pryor was making a concerted effort to distance himself a bit from Lori and her defense team. So ultimately, the judge denied the motion and told them that they had to do what every other co-defendant does, and that is talk through their attorneys, communicate information through their attorneys. But I have also heard, and I don't want to out sources, but I have heard from at least one source that there may be a serious plea offer on the table. It's not at all surprising. This is really the time during a case like this when you would be seriously entertaining plea offers. It's sort of the typical time for that to happen. So those were the big motions that had to do with Lori and Chad, or both, or one or the other of them. So the judge decided those motions, and then he excused Chad. Chad left, and Lori remained with her counsel while the judge took up 4 motions having to do with the death penalty. Jim Archibald, as we discussed last week, Jim Archibald made clear that these are standard motions that are made in every death penalty case across the country, and that the hope is at some point that one of those motions will go up to the U.S. Supreme Court. So he certainly didn't devote a lot of time to argument, nor did the prosecution. Both of them sort of relied on their written motions and responses. And the judge in all four of those cases, those motions, one was to declare the death penalty unconstitutional. One was to declare it unconstitutional to death penalty to qualify jurors as death penalty jurors. One was to say that the death penalty did not apply to Lori because of the way that the charges were brought. And the last one had to do with declaring the death penalty on its face to be unconstitutional. So those were all pretty theoretical motions that are made in every death penalty case. And the judge took all of those under advisement and said he would issue written rulings. Now, I have to say that I thought Judge Boyce seemed more confident. He seemed more thoughtful about the motions and the arguments that were made. And I thought that he quite appropriately ruled from the bench on the motions that he could, and then agreed to issue written findings on the motions that will most certainly end up at the appellate level, the death penalty motions. So I thought he actually did a creditable job this time. He didn't seem nearly as off balance as he has at some of these. Chad was there in his usual long-sleeved white shirt and tie. He looks a little soft and doughy, but he also looks a little haggard. It was interesting that after Chad was ushered out of the courtroom and Lori was there alone with her lawyers, her demeanor was different. She was a little more giggly, a little more flirty, a little more outspoken. We saw her talking to her lawyers, talking to talking to the security folks who were there with her as well, the deputies. So it was marked that the difference in her kind of overall demeanor once Chad was out of the room. So I thought that was interesting. They didn't look at one another a lot. It was interesting. Chad was sitting there staring straight ahead. When they brought Lori in, she sat down. She looked over at him. He didn't look her direction. And the attorneys, John Pryor and Jim Archibald, who are both pretty big guys, promptly stood up and kind of moved in between their clients so that there wasn't a lot of eye contact happening, sort of put themselves in between them. Lori then later sort of leaned far back in her chair at counsel table so she could see behind her attorneys and look at Chad. Chad glanced over at her 2 or 3 times, but nothing prolonged or nothing. And he was pretty expressionless when he did it. So I still, based on what we saw, I still think that John Pryor is very clear that he has a defense, and that defense is going to include throwing Lori under the bus. And it will be interesting to see how things go forward. If Lori were to take a plea, then Chad would have some very serious thinking to do. Because once a person enters a plea, they're no longer protected by the Fifth Amendment right to self-incrimination, against self-incrimination, because they've already pled. And so it is possible that the prosecution could call Lori to testify against Chad. And I think that I don't think that's anything either one of them wants. So I think that was the reason why Jim Archibald and Lori were so hot on trying to get a dialogue going with Chad, because I think I don't think anybody wants to have one of them actually testifying against the other. So, interesting things to think about. We're at that portion of the evening where we're going to invite questions. So please get your questions in the chat. And it looks like we've got some going already. So hello, Sabrina. Says CD barely noticed LV in court, and Pryor said they're not interested in strategizing with Lori Vallow. If his defense is she framed me, I think Lori Vallow will absolutely make a deal and testify against him. Thoughts? You know, I don't know that I don't know that she would. Her intention would be to make a deal and testify against him. I'm not sure. I think that she is still in the mindset that this is my husband, he is the head of my household, he is in LDS terms, he is my priesthood holder, and so I'm not entirely sure that would be her first motivation. I think that if, as we expect, that Chad is going to say that he was framed, then I think we may see Lori make a deal and be called to testify. I just don't think it would be her first thought, her first response. Thank you, by the way. I have seen many super chats go by this evening. Thank you so much for our moderators. Every little bit helps, and I appreciate them so much. I couldn't do this if I didn't have Brenda and Michelle being so faithful. So thank you for recognizing that. Hi, Natalie. Question: were Chad's kids in court supporting their dad? They were not. They have not been in court any of the times that I have been there. I know that they were in court the day that he was arraigned, because we could see them, the cameras. At that point, there were still cameras in the courtroom, and we could see them all wearing masks, COVID masks. So I don't know that it's all that surprising that they're not coming to court. Coming to court is really running the gauntlet, and I think that they are keeping a low profile, at least until the trial. Hello, N, with the cute little Himalayan kitten. Question: can lawyers talk about the deal between themselves without defendants? Can defendants exchange letters through their lawyers? In general, they don't exchange letters through their lawyers. They exchange letters through the prison mail system, which assures that the letters come in without any contraband in them. They don't have any staples. They don't have any, and that they can be properly redacted in the case of there being inappropriate information being exchanged. They can talk about the deal between themselves. The lawyers talk about the deal between themselves and without the defendants, probably at length. I think they will be talking about what the deal looks like, what sort of admissions the prosecution is going to require in order for them to take advantage of the deal. So they will talk at length about a plea. and they will relay information from the other side back and forth, from the co-defendant back and forth. But they will not be allowed to talk directly. So as far as I know, they can exchange letters, but all of those letters have to go through the prison mail system. If criminal defendants take a plea deal, is the public still able to access the evidence the prosecution collected against them? Yes, because the Freedom of Information Act applies. And what that means is the Idaho Freedom of Information Act says that you can't get that information before the case is adjudicated. Now, it's different in Arizona, which is why we got that big dump from Arizona. Because in Arizona, there isn't an exemption for something that's pre-adjudication. But in Idaho, cases that are pre-trial that are have not been, that there hasn't been a judgment of conviction entered in, or they haven't been dismissed, then you can't get that information until the adjudication happens. So once the case is adjudicated, that exception no longer applies, and that information should be available through Freedom of Information Act request. Now, the thing that may not be available without a court order is going to be those sealed documents. However, the purpose for sealing the documents will have expired with the adjudication, and it would be very suspicious for a court to continue to keep documents sealed post adjudication unless they meet the exceptions that are typical for personal information, medical data, those sorts of things. Good questions tonight, guys. Hi, Trisha the Trucker. Where are you tonight? I'm always interested to hear where you're holed up tonight and hearing us. Question. If they both take a plea deal, then Zulema, Melanie Gibb, and Melanie P. don't testify. Does that mean they won't get their immunity deals? Can they be prosecuted? Well, no. Well, they'll get their immunity deals. So they have already provided information to the prosecution, which has helped the case, undoubtedly, because otherwise there wouldn't be an immunity offer. So they have already provided information to the prosecution, and it's likely that some of that information may have been, may have helped convince Lori and Chad that they couldn't win and they should take a plea. So in that regard, they have fulfilled that part of their obligation. The other part of the obligation is to come to court, show up, testify truthfully. They won't have to do that part if Lori and Chad take a deal. But that means they will have fulfilled their part of the bargain. And usually an immunity agreement includes a clause that says that should the defendant enter a plea prior to trial, that the obligation for the witness to come and testify is extinguished. So they would get their deal as long as they've upheld their side. And we don't really know, other than Zulema, who may have immunity. We have speculated with some pretty darn compelling evidence that both Melanies have immunity as well. The reason why I have speculated there and have sort of come to that conclusion is when Mark Means, back in the what seems like the dark ages now, back when Mark Means was on the case, he served Melanie Gibb with a discovery demand. It was an odd filing, but he's not a criminal attorney. And he served Melanie Gibb with that discovery demand. And her first response was to say to the process server, try and hand it back to him and say, take this to Rob Wood, call Rob Wood, which to me says Rob Wood is my guy. He's my savior. He's the guy who's going to make sure that this is that I don't have to deal with this. And on Melanie Boudreau Pulowski's end, Melanice, as we call her, she was charged with 3 counts of identity theft, having to do with getting into Brandon Boudreau's bank accounts after they were divorced and after the divorce decree said she was no longer allowed access to those accounts. She was charged, and those charges stuck around for 3 days maybe, and then they were dismissed. They disappeared. So to me, that sounded very much like, here we have these charges, and we'd be happy to give you immunity from those charges if you would only just come and testify at trial truthfully about what you know. So I think we've surmised that they have some sort of arrangement. Hard to say what the actual boundaries of those agreements are, but we do know Zulema has one, and we speculate that Melanie and the 2 Melanies have them, and they would get the benefit of their immunity deals as long if Lori and Chad took a plea, as long as the prosecution was convinced that they would have come and testified had they been called. It's a red wine night. I'll tell you what, it was cold in Rexburg. I think it was the morning of the motion hearing, I think it was around 17 degrees. So it was very cold in Rexburg. It's been cold in Boise, but not quite that cold. And we've had a couple little dustings of snow. We have a little snow on the ground, but fortunately not much. I was able to go out and shovel our sidewalk this morning. Hi, Polly. What ideas do you think the plea deals will be? Well, in general, I think probably the most significant part of the plea deal will be a deal for life in prison without the possibility of parole, rather than the death penalty. While the hearing was going on, Jim Archibald made an excellent point having to do with the death penalty in Idaho. He actually went through and talked about each one of the 8 people who are on death row, 7 men and 1 woman. Every one of them, with the exception of 1, have been on death row for 20 years or more. Those people who are on death row have gone through numbers of appeals, and recently, a couple of months ago, a court issued an execution order for one of the 8 people, one of the 7 men that are on death row, and the state of Idaho had to ask that execution warrant be vacated because they could not obtain the drugs and the chemicals that are required to do lethal injection. We've talked about this before. It's becoming more and more difficult for them to be able to obtain those materials because the companies that make them are refusing to sell for the purpose of lethal injection. So the state of Texas has developed a different way of doing it. They go to a compounding pharmacy, and they have a compounding pharmacy compound and create the chemicals and the drugs. They are somewhat different than the typical formula that is sort of the accepted formula for lethal injection. And I've come under criticism for it causing pain and causing anxiety and not being the most effective or pain-free way to administer, and that falls under the heading of cruel and unusual punishment. So A lot of states are really in flux right now, trying to decide how to go forward with executions under these circumstances. Many states have gone to only using lethal injection, which means that there aren't alternatives if they can't get those chemicals. Most of the people who are on Idaho death row have been at least 20 years, and in several instances more than 30. So the plea deals certainly will likely be life in prison without parole, and it may be for one or the other of them, depending on who's rolling on whom. It may be with the possibility of parole. I mean, that would be a big carrot. I sort of doubt they would do that, but there's a lot riding on it, millions of dollars in appeals and the cost of trial. And, trials aren't 100%. They're not certain. So prosecutors often want certainty in economy. Monty D. It was stated that the new sample was recently discovered. How can that be? Is that one of the reasons the bodies haven't been released? And does it mean they're still looking at them? I don't know. I somewhat doubt it. I think that these were hairs that were recovered from the duct tape. Duct tape is like flypaper. I mean, it's super sticky and everything sticks to it. And there was if you recall from the description from the preliminary hearing, when the police officer testified about the condition of JJ's body, it was wrapped in layers and layers and layers of duct tape. So there's a lot of sticky surface to go over, a lot of places where nooks and crannies where things could be missed. My understanding is it was hair. Not all hair can be DNA tested. Not all hair contains sufficient DNA to test. And so what the prosecution said was the lab has doubts about whether or not there'll be sufficient samples to test. So but I don't believe that they're still looking at the bodies. Hi, Carrie. If Lori or Chad tell their lawyer that they are guilty, does that fall under privilege or not? Good question. Yes, it does. No matter what your client tells you, it falls under privilege. You cannot repeat, even your client confessing, you can't repeat. Where that gets thorny is if your client then intends to get on the stand and say, I'm not guilty, I'm innocent, I didn't do this, and has told you the opposite, that they are guilty and that they did the crime. Because you, as an officer of the court, cannot suborn perjury. You cannot allow your client to go up on the stand and lie and say something you know is not true. This is the reason why many attorneys advise their clients, don't tell me whether you're innocent or guilty. If you want me to put on a defense and prove that you are not guilty, don't tell me if you're not, because that is going to impact my ability to put on a robust defense for you. So I know it seems kind of counterintuitive, but we cannot, as lawyers, cannot allow someone to knowingly allow someone to get on the stand and lie. People lie on the stand all the time, but we can't be a party to it. So, hello, Glowing Ember. What a great name. Why would Chad or Lori want to take a plea deal? Remember, they're translated beings and cannot die. Well, I think that sometimes lengthy incarceration can cause you to revisit things that you might have thought or believed when the case began. So it would not surprise me at all for reality to come crashing in on both of them, and for both of them to determine that they are, in fact, not at this point translated beings who cannot die. The issue, the concept of translated beings. Now, y'all who follow me know that I have been up to my eyebrows in mainstream LDS doctrine, offbeat LDS doctrine, Daybell doctrine, all of it. So now I'm talking about my understanding, and I always have to preface this by saying I am not LDS, did not grow up in the church, and so I'm going to pass on my understanding of what I have read. The mainstream church believes that there are a handful of historical beings who are translated. And what that means is that they can move back and forth between heaven and earth, and they indeed aren't subject to the same physics and the same physical characteristics as the rest of us. These are a very few handful of biblical historical figures. They do not ever include the rank and file members of the LDS Church. In order for a person to be exalted and go to the celestial kingdom, they must have lived an exemplary life and followed the rules, but that is different than someone who is a translated being. Translated beings are saints, people who and prophets who do God's work by moving back and forth between the two kingdoms, planes of being, if you will. If they take a plea deal, will we ever find out the details of what happened? Will they have to tell? So if they were to take a plea deal, the judge would go through a discussion with them about their what they did that constituted the crime. So there would be some discussion. Usually what happens is the attorneys provide enough of the factual recitation of the case, and then the judge asks the defendants, how do you plead? And they say, I plead guilty. Whether the judge would actually require them to repeat a colloquy of exactly what they did, it's doubtful. But we will find out, because once the case is adjudicated, all of that discovery information is going to be released, redacted, to protect medical and personal information. But we will see a great deal of what prosecutors have right now. This is a question we get all the time. How is it legal for a defense attorney to know in their heart that their client is guilty and create another story trying to get an innocent verdict? The defense attorney's job is to call to the attention of a jury, or the finder of fact if it's the judge, the holes in the prosecution's case, the places where the prosecution has not proven beyond a reasonable doubt that the defendant is guilty. The defense attorney's job is to protect that person's rights, and that includes the right to remain silent, the right to be presumed innocent, the right to a speedy and fair trial, the right to due process under the law. All of those are things that defense attorneys, it is their job to protect their clients' rights. Remember that your client is presumed innocent until proven guilty. So it's not just enough to say, I suspect my client did it. My client, Chad Daybell, Lori Vallow, are presumed innocent unless and until the prosecution proves beyond a reasonable doubt that they are guilty. And it is the defense attorney's job to poke holes in the defense case and to point out the places where reasonable doubt can sneak in. That's our system. So not only is it legal, but it is absolutely required that a defense attorney, regardless of what I know or think, it is my obligation to make sure that my client's rights are protected and all of those rights are and the process is adhered to in every way. So it is our system, and they are presumed innocent. Hi, Sherry. It says, I listened to Nate's recording of the hearing. Sounded like Pryor got very heated several times when addressing the court. Did you witness this? And what was your take of his demeanor? John Pryor tends to be a little bombastic, and he tends to get himself a little wound up sometimes. I think all lawyers do that. Some of it is theatrics, and some of it is sincerely held outrage. And I have to say, I think that John Pryor is sincerely outraged by the fact that he is less than 90 days from a death penalty trial, and he still does not have crucial and potentially exculpatory DNA evidence. And I could understand him being pretty outraged over it. He tends to be a little bombastic and a little heated and gets a little excited. And that's not everyone's style, but I think that it's his style. I think he genuinely is outraged by the fact that the state has not given him all the information and all the discovery that he's entitled to. But I think that he plays it up a little bit more than probably is necessary. Nate's recording, I wanted to address that. Actually, what Nate did is every proceeding in a courtroom is audio taped, and that audio tape is part of the court record. So what Nate does after each one of these hearings, since cameras are no longer allowed, is he requests from the court administrator a copy of that recorded. It's in place of a court reporter, because we don't use court reporters anymore. We use audio recordings. So it just means that the recording was the official recording of the court, and Nate got it from the court and then posted it on his site. In fact, I asked him, are you going to get the recording? Do I need to request it? He said, no, I'm going to post it this afternoon. So it was available for anybody who wanted it. Oh, this is a good question. The reels 360, there are 36 ounce. I'm not sure whether. Can you refuse a case if you're a public defender? It varies from state to state, but in general, public defenders are allowed a limited number of types of cases that they're not comfortable with. And it varies from lawyer to lawyer. I mean, I had a colleague who was a very faithful Buddhist who was her deeply held love for animals, and she absolutely could not take an animal abuse case. Just went against everything she believed in. She defended homicide cases, but would not take animal abuse cases. And so there's kind of a combination in our group. We all knew that that was something that we weren't going to ask her to do, and so we just allocated cases around that. I think that there are some clients who find child sex abuse cases extremely difficult, some lawyers, and so I think sometimes those but I would say that public defenders kind of self-select. I mean, if you are not prepared to take the bulk of cases that are assigned to you, you kind of self-select out of that area of practice. I think for the most part, you'll find public defenders are more excited about a juicy, complex case than they are about, oh God, another DUI, or oh man, another meth case. They're not as challenging and not as interesting, and there aren't as many interesting legal issues to tackle in those sort of straightforward, run-of-the-mill, everyday cases. But most jurisdictions do allow a limited number or a limited reason for refusing a case. Now, refusing a case is different than conflicting out of a case. So I could have a conflict because I previously represented a co-defendant or something like that would disqualify me from a case, but it wouldn't be because of a conscience issue. Hello, Intervisions. Thank you so much for your donation. We appreciate it so much. Our mods appreciate it. And I appreciate it. It might be Friday night pizza tonight for my girls. John Pryor took issue with the word strategizing. The process is going to be trial prep. There's going to be no strategizing. This is trial prep. What's the difference? Well, depends on who you ask. I think Scott Reich kind of got a kick out of this and said, yeah, that's trial prep. And I think in some ways he's right. But I think what John Pryor was trying to say was these are not two co-defendants who we want to get them face to face so they can get their story straight. This has to be trial preparation. And what Pryor did say was, I want them to be able to talk to one another so they can compare notes about witnesses and what witnesses will say. And perhaps they know, they remember a conversation that they had with Melanie Gibb and Chad wasn't there when that happened, those sorts of things. So he was really pointed in saying, we're going to be talking about witnesses, what they're going to say, who they are, what they're going to testify to, what you remember about the witnesses, whether or not there are places that we can poke holes in their credibility, those kinds of issues, rather than let's sit down and get our story straight before we go to trial. And I think that's where Pryor was just saying, this isn't a strategy session. John Pryor was very clear that he knows and has an intention for his defense, his theory of the case. And that theory of the case isn't going to change depending on what Lori and her attorneys do. So it's not a matter of coming up with a strategy or a theory of the case. That Pryor is very clear he's done. And I think Pryor saw that idea of strategizing really could be misconstrued to be thought to be getting their story straight. So he was sensitive to that. I've been watching our viewer count, and We're at 498, we're at 497, we're just edging on to 500, and we're not quite there yet. So thank you so much for all of you who have joined us tonight. I appreciate you being with us. I especially appreciate all of the lovely support tonight for our moderators. Lisa Miller asked, yay, we just hit 501. Thank you. Please, if you have not subscribed, please subscribe. It does make a big difference in the way that YouTube views us. Please hit the like button and do ask for notifications, because as the trial gets closer, we're going to do some impromptu lives, particularly having to do around the trial. We're going to be doing some YouTube shorts, keeping everybody advised on what's going on in the trial, because there aren't, as far as we know, not going to be cameras. Lisa Miller, do you think they would really have to start the trial over if Pryor's demands were not met? Who decides if the attorney didn't do a good enough job, so they have to do the trial over? So what would happen is the trial will go forward either in April or at some later date if for some reason the judge severs the trials. What the judge said was, if there is potential exculpatory information, DNA information, that has not been provided to the defense, he would be inclined to sever the cases and give Chad more time. So it is possible that the cases could be divided. It is the decision of the appellate court. It is up to the appeals court to decide whether or not an attorney has done a good job. And we've talked at length about that's kind of a high hurdle to get over, because we have to start by saying, did this attorney, in the circumstance that he was in these facts, with these facts and in this circumstance, did the attorney fall short of what a reasonable attorney should do? So that's the first question. And then the second question is, it's a no harm, no foul. They have to be able to prove, the defendant has to be able to prove that the outcome of the case would have been different, except for the inadequacy of his or her counsel. So it really turns on the, did the lawyer mess up so bad that I would have been found not guilty had it not been for their incompetence? So I think it's going to be a high hurdle. I know that John Pryor is concerned about it. It is possible that a court could find ineffective assistance of counsel and could give Chad a new trial. That would be up to the appeals court to make that determination. We're coming up on the hour mark. I like to finish right at the 1 hour mark. So let's just see if we've got one more good question. Otherwise, we'll see if we can wrap up and be true to our time. Kathleen Smith asks, John Pryor said that Mr. Daybell would fire him for incompetence if the trials weren't severed, I think. Could Chad do that so close to the trial date? Chad could. I've seen this happen before, but what has happened before, in my experience, has been a judge saying, be careful what you wish for, because you're still going to trial with a new lawyer. I actually had a case with a mandatory sentence. It was an armed robbery case, and the defendant had changed lawyers several times, had asked for new counsel, and got really close to trial and said, I want a new lawyer. And the judge said, okay, but you're going to trial anyway. And I had 11 days to prepare for that trial. Surprisingly enough, it was not ineffective assistance of counsel when it went up on appeal, because I had done an adequate job considering the circumstances and the fact that I had been on the case 11 days. So he could fire his attorney, but it is also possible the judge could say, regardless of that, you're still going to trial. I don't think that Chad Daybell would fire John Pryor for incompetence. I think the more likely scenario is that the appellate court would find that he didn't have effective assistance of counsel. So I want to thank everybody for being here. We hit the over 500 mark tonight. I appreciate you all being here. And I hope that you'll join us on Wednesday, where we'll be talking on True Crime Wednesday. We'll be talking about other cases. There have been some incremental developments in the University of Idaho Brian Kohberger case, so we'll talk about that. A couple of other interesting cases to talk about as well, some developments in those. And so I appreciate you all being with us. Thanks so much to my moderators. Thank you so much for your generous donations for them. And I will see you on Wednesday. Have a great weekend and stay safe out there until Wednesday.